My name is Ben Griffith, and I'm going to give about a 10-minute talk on voter identification litigation that's going on in different places and hot spots in the country. About 2.5 weeks ago, the Pennsylvania State Court for the Commonwealth of Pennsylvania handed down a decision in which the court denied injunctive relief to stop the implementation of the voter identification legislation in that state. The court, in a well-reasoned opinion, and I think very thoughtful, essentially followed the U.S. Supreme Court's Marion County versus Crawford, a decision from from 2008, just a few years before. In that decision, the U.S. Supreme Court had upheld Indiana's voter identification law in a facial challenge brought against implementation of that statute. This latest decision in Pennsylvania was the first out of the box in a series of challenges that have been brought by minority groups and voting rights organizations like the ACLU, Lawyers Committee for Civil Rights Under the Law, and other organizations that have challenged voter ID laws as inherently discriminatory and having an inappropriately burdensome effect on the right to vote on the part of minorities, the elderly, those who are perhaps in the broad category of discrete and insular minorities, and others that are burdened by the process of having to get a photo identification. The quick answer to much of the complaint in the Pennsylvania case was that voter identification was not unconstitutionally burdensome. The court, in adhering to the Crawford line of reasoning, basically said there's not an excessive burden being placed upon people to get a photo ID. The Pennsylvania case did have a lady, Ms. Applewhite, who I think is the poster child for voter identification litigation. She was in her 90s. She had voted for every president since John F. Kennedy. She had marched with Martin Luther King. And she didn't have a voter ID because she didn't have a birth certificate. She had been adopted. The birth certificate had never been obtained, or if one had been, it was lost. She didn't have any need for a car, had no driver's license, had no need for a photo ID or any form of identification other than that which she used in voting and participating in elections for decades before this time. Well, that's the Pennsylvania case. The most recent case is decided by the three-judge court in Washington, D.C. in a Section 5 proceeding seeking judicial preclearance of Texas voter ID law. There, the three-judge court, in an opinion written by Judge Tattle, himself a former member of the Lawyers Committee for Civil Rights Under the Law, had very extensive findings made that the voter ID law in Texas was, among other things, the strictest in the nation, and it did not provide adequate alternatives for individuals without the ability or funds to pay what could amount to about $22 to purchase a photographic ID or to obtain a birth certificate in order to obtain a photo ID. There were other burdens, though. Many of those burdens were not very clearly articulated at the time Texas passed the legislation. I'm not suggesting that Texas did anything wrong, but this being the strictest voter ID law in the nation, I think it merits appropriate scrutiny. One thing that Attorney General Abbott did present, and I think he did, from all I can read about the proceedings in the three-judge court, he did a very, very good job. He was under extreme pressure. There was an accelerated timetable that makes the Eastern Division of Virginia's rocket docket look like a snail. And in that case, the Texas legislation was presented, discovery was truncated, but there were efforts made, I think successfully, by those challenging the Texas law that showed, as applied, the Texas voter ID law could potentially have a significant negative effect upon the ability of minorities, particularly Hispanic citizens, to participate in the electoral process and participate as citizens in the electoral franchise. Biggest problem in the Texas case, and I've read through the decision several times. I've talked with a buddy of mine who's crazy enough to do voting rights litigation like I am. The court literally gives a blueprint for how to do it right. And I think it would merit, I think, some attention being given by other states that are about to undergo these challenges. One similar case is pending right now in South Carolina's challenge brought with respect to its voter ID law. That also is a three-judge proceeding, three-judge court proceeding brought under Section 5 of the Voting Rights Act, both South Carolina and Texas being covered under the preclearance provision. In the Texas case, though, the three-judge court said at the end of its decision, it's the very last page, in effect, the Texas legislature had numerous opportunities to slacken up, ease up, make easier, provide less restrictive alternatives for the voter ID law, and didn't do so. And it gave what I thought were 5 potential less restrictive options that could have been pursued, and if incorporated into this law, could potentially have spelled the difference between not passing muster under the new Section 5 regulations as adopted by the Attorney General last April of 2011, and actually passing the effects and purpose test of Section 5. What the court said was the legislature in Texas at the time this law was passed tabled or defeated amendments that would have waived all fees for indigent persons who needed the underlying documents to obtain an identification card, could have reimbursed impoverished Texans for EIC, that's election identification card, related travel costs, could have expanded the range of identifications acceptable under the Senate Bill 14 by allowing voters to present student or Medicare ID cards at the polls. It could have required the Department of Public Safety in Texas to remain open in the evening and on weekends, and could have allowed indigent persons to cast provisional ballots without photo ID. Now, get me right on this. I'm not saying that incorporation of every one of these provisions would have guaranteed Section 5 preclearance judicially of this legislation, but I think the court was signaling, and I think the signal is one that perhaps some of us who've been in these trenches for quite a while could pick up on. I think, on the other hand, the pending litigation that is going on in South Carolina ought to have a reasonable shot, a reasonable opportunity of passing muster under Section 5. Attorney General Wilson in that case was also on a panel at the ABA annual meeting just a few weeks ago in Chicago, and pointed out accurately that the South Carolina voter ID law did have numerous ameliorative and less restrictive alternatives for the photo ID. There was no cost, and there was under no circumstances a way in which costs would be incurred by a person seeking a photo ID. I think he made a very, very good point in that quite heated CLE program. If you can remember all the different sides involved in these cases, it's quite a bit of emotion that's expended in them. I would have been the one caught right in the middle of all the discussion. But I do want to emphasize this. You've got over 30 states that have passed voter ID, and one state, Pennsylvania, is a swing state in the presidential election coming up in just 2 months. Another state is Texas, also a swing state. Its voter ID law has been basically stricken. Without passage under Section 5 of the Voting Rights Act and without preclearance, it cannot be effective as law. And there's no time for any type of emergency appeal. What you've got in front of you now are a number of state laws, some having been stricken in their own proceedings or by the legislature or governor's vetoes. I don't want to get into the minutiae of those, but the 2 principal cases that now are setting out the battleground of the issues in the legal and analytical process of approving or disapproving voter ID laws are the Pennsylvania case and the Texas case. My prediction would be you're going to see a number of other cases tried in short order between now and right before the November general election. I can't predict the outcome of all of those. I'm not that smart. But I do know that the voter ID legislation as it presently stands in Texas, if it is going to be revisited, would best be revisited in light of these 5 particularly relaxing or less restrictive provisions that the 3-judge court under Circuit Judge Tattle has pointed out and elucidated for the court. That said, voter ID is not inherently a bad thing, although the proponents of it often come forward with claims of fraud and efforts to prevent fraud, saying that voter ID does prevent voter fraud or voter identification swapping or misidentification or persons who are impersonating another and trying to vote. Those instances do occur. They don't occur in great numbers. Texas has done a fairly good job, I think, of showing a number of instances of voter fraud. Other states have actually presented evidence. Kansas did, of several hundred instances of voter ID fraud, voter identification related fraud. It does happen. My biggest problem is that on both sides of this issue, not just the emotions are high, but the rhetoric is unduly extreme and polarized. Both sides ought to be spiked. I think what I would like to see is a little bit more analytical, straightforward, factual discussion without this type of emotional debate. It can't become non-emotional this close to a re-election of our president or the defeat of our president. It's just not practical to deal with this issue in a way that's non-emotional. But I do think that when all the dust is settled after this election, there'll continue to be challenges to voter ID. Some of the challenges will pass, some will not. Out of the 30-plus states that have voter ID, my prediction would be for those that aren't covered by Section 5 of the Voting Rights Act, they're likely going to be following the Pennsylvania reasoning. That court followed the Crawford versus Marion County reasoning to the hilt. And I think that in and of itself shows that the Supreme Court does not consider photo ID per se unconstitutional, at least in a facial attack. Tremendous efforts have been made to distinguish the voter ID case in the Crawford case, but I don't believe those efforts to distinguish it have been very revealing. One thing I do want to close with is a quote from Governor Huey Long's brother. If you remember the movie a number of years ago, Blaze, this was Earl Long. He was Louisiana governor after his brother was assassinated on the Capitol steps. And he's got a quote attributed to him. I've checked it out. It's actually true. And it is, "When I die, I want to be buried in Louisiana so I can stay active in politics." My name is Ben Griffith. I practice in a law firm of Griffith in Cleveland, Mississippi. A good part of my practice is governmental litigation, federal civil litigation, and a lot of that under the Voting Rights Act, election law and voting rights cases. I'm active in the American Bar Association, member of the House of Delegates, past chair of the state and local government law section, and I'm chair in my third year of the ABA Standing Committee on Election Law. None of my remarks, no conclusions I've reached, no statements of opinion are to be attributed to or reflect the views of the ABA Standing Committee on Election Law. I want to make that very, very clear. Other than that, it's been a pleasure to participate in the YLD's program. I think this is outstanding. What you're getting is pretty spontaneous remarks and observations from attorneys that are involved in different fields of the law, and I hope this has been helpful. Thanks very much.